people of YouTube, Sister Danger here. I hope everybody has had a really great holiday season so far. Today I'm going to be doing a video response to some questions that were asked on a topic that I posted to my Facebook page a couple of days ago. And it resulted in a number of questions and counter arguments, if you will. And so I'm going to attempt to address those questions and counter arguments in an orderly fashion. Now, the topic at hand is this new law in New York City, which can potentially result in up to a $250,000 fine to employers and landlords if they are found to have discriminated against transgender people by misgendering them. I'm going to dispense with the red herrings and straw men right up front, and the first objection that was made to me was that this news article, which I reposted, was from Breitbart Tech, and that Breitbart Tech is a sensationalist news source. I am neither discussing nor am I concerned with the news outlet that I first saw this story on. So yes, you are correct. I have not addressed the fact that Breitbart, in your opinion, is yellow journalism because it doesn't matter. I don't care what Breitbart's writing style is. I don't care what Reuters' writing style is. What I care about is what I can confirm. There are several questions in this next clip here, and I'm just going to go ahead and take them out of order so that I can provide some continuity. Do you think Breitbart deserves any recognition or even usage as a primary fact source for anything, considering its agenda? Well, the answer is relatively simple. I'm not actually relying on Breitbart as some sort of a fact source for the formation of my opinion. Breitbart actually posted a link to the New York City Commission of Human Rights, which in turn links back to the New York City law on this topic. And I availed myself of that link and formed my opinion based on what I read in the actual legal documentation. Since I've been asked what could possibly be the concern with addressing people by their preferred pronouns, let's turn our attention to the actual verbiage in the documentation and take a look at some of the more concerning points. Gender is defined as one's actual or perceived sex and shall also include a person's gender identity, self-image, appearance, behavior, or expression, whether or not that gender identity, self-image, appearance, behavior, or expression is different from that traditionally associated with the legal sex assignment to that person at birth. The documentation then goes on to say, the definition of gender also encompasses discrimination against someone for being intersex. Under the NYCHRL, gender discrimination can be based on one's perceived or actual gender identity, which may or may not conform to one's sex assigned at birth, or on the ways in which one expresses gender, such as through appearance or communication style. Now that all seems well and good until you realize that the United States does not have a uniformity of gender laws. States, to varying degrees, have medical and bureaucratical hoops that a person must jump through in order to legally change their sex that has been represented on their original birth certificate at the time of birth. 4 states in the United States, being Tennessee, Kansas, Ohio, and Idaho, do not allow a legal change to your birth sex on your certificate, no matter what. It is not a possible thing to do according to the law in those states at this time. Effectively, these policies have the potential to undermine the only authoritative source of a person's proper gender reference. This poses a problem for businesses because businesses are required to undertake certain legal activities that require using a person's real name and gender as it is represented on their legal government documentation. Some of these things include filing taxes on their employees, insurance, 401k plans, any sort of legal documentation or notification. If there are reviews, if there are reprimands, contractual obligations have to be made under a person's legal name and identity. The list goes on. Further, what happens if you come from a state like Idaho where gender reassignment is not possible on your birth certificate and you move to a state like New York where now entities are obligated under penalty of a fine to deal with you as however it is that you've presented yourself, the gender identity that you publicly display? How is a landlord supposed to draw up a legally binding contract if they do not have an authoritative source of a person's name and legal identity. What happens if somebody changes their identity during the course of living in a place or working at a place? How is the company or the landlord supposed to respond to that, especially if they aren't given notice of this fact? Landlords are required to send certain documents to the people who are their tenants. For example, notice of entry or inspection. All those have to be sent to a tenant. Any revisions to a rental contract have to be sent prior. If you're going to evict somebody, all of these things have to be done in that person's name. If there's no onus of responsibility on the transitioning person to notify their landlord, for example, then how is the landlord supposed to deal with any sort of changes in identity during the course of time that that person is living on their property? What if the person is in the middle of a transition or has recently completed a transition and these documents need to be drawn up? How is an entity supposed to deal with that? What if the entity is a workplace and somebody is transitioning? How is the workplace supposed to handle this situation with respects to their other employees so that those employees do not accidentally transgress upon this person who is going through these medical procedures and physical transforming? Is the company responsible for sending out notices to all of its employees via memo that John Doe is about to become Jane Doe? How are bills supposed to be issued by, say, cable, internet, or public utilities companies? If a person can insist that the bill be put in the name of whatever identity they are presenting and not the identity that is on their legal documentation. How are companies supposed to collect on those bills if the customer defaults? How often, if ever, should an employee be responsible for notifying their landlord or their place of employment of any gender changes? Should companies, under penalty of a fine, have to conform to using a gender identity which is socially preferable but not legally documented when the government doesn't have to do that? These policies create a punitive action against entities which are being legally required to potentially conform to two different sets of opposing laws. And there is no final authority or authoritative law on a person's identity. While the intent of the law to bring equality to trans people is fantastic, the effect of the law is that it makes trans people walking liabilities to employers and landlords. If we want to see what happens in this sort of scenario, we don't have to look very far. The American Disability Act was intended to do the same thing, to bring equality to disabled people in the workforce. Unfortunately, it has had exactly the opposite consequences of its original intent. Thomas Dellier discusses in a labor paper titled The Unintended Consequences of the Americans with Disabilities Act that theories of labor demand predict that when a group of workers becomes more expensive, firms will hire other workers or substitute capital for labor. In short, it is cheaper for companies to simply not hire trans people than it is for them to either make accommodations for their special needs or to run the risk of the litigation that could happen if they were to incur a lawsuit. This chart here shows the rates of employment for men with and without disabilities before the ADA and after the ADA, and the rate of change between the two. As you can see, the rate of employment after the enactment of the American with Disabilities Act went down. And the reason for that is simply because these people became more of a liability to employ than to simply just not hire in the first place. All of this would be much more easily dealt with if we had a uniform method of legally determining and changing a person's gender and identity, and then companies would then be required to comply with whatever that legal identity was. Forcing companies to comply with social policies that are set in contrast to state and federal laws is basically setting trans people up to be the next unemployable demographic. And rather than integrating them into the workplace, they will become more excluded from the workplace. That result seems to be in direct contrast with the intended desires of these legal updates, which really doesn't bode well for the trans community, and that's what makes me say that this law is bananas. Thank you everybody for watching. If you like my videos, please hit that subscribe button. And if you really feel generous, you can hop on over to my Patreon and support me there. Otherwise, feel free to find me on Facebook and Twitter or G+. I hope you all have a happy new year.